Thank you, Mr. Chaudhary. I think that was really, really insightful. And you did touch upon some of the very interesting topics. Starting and taking a cue from there, where you did mention that IBC actually has, been a watershed moment for India. And we have really seen a lot of successes. So we definitely should talk about the success stories a little more, so that we are encouraged to, go to IBC and to rely on IBC a little more. However, I mean, we cannot also overlook the fact that in today's time, there are considerable time that is being taken. The reasons could be multiple. So when we are talking about the amendments in IBC, I think it is also important to understand one of the key amendments that is being sought. One is to have an integrated technology. That platform, it would be interesting to actually understand how does that platform actually connect the stakeholders in that sense. And the second more important aspect that we actually would want to understand, and that is why I would immediately jump into the session with Mr. Madaan, to talk about what are the kind of systemic changes that are actually required, Mr. Madaan, to be able to cut down the 600 days that we talk about, and we talk about there being delays, and is really there a delay as such? And if yes, what are the kind of changes that can be brought in our system to be able to efficiently utilize the time and cut down on the 600 days to say 330, that is the original agenda for the legislature?
Thank you. Thank you for giving me the opportunity. You're talking about delays. Nowadays, if you speak to any of the stakeholder, or particularly the media, they will always say that delay is on the part of adjudicating authority. And exactly that is not the case at all. If you see the functioning of NCLT, the NCLT members, NCLT infrastructure, all this dates back to 2002. Or for all those who are company law students like me and the practitioners, they know that NCLT is nothing new, though everybody knows the company NCLT is coming to existence in 2016. But the provisions with respect to constitution of NCLT and role of NCLT has been there in Companies Act 1956 since 2002, when through Companies Amendment Act 2002, the provisions with respect to NCLT were introduced in the law. That's a separate issue that the provisions were challenged earlier before Madras High Court and then before Supreme Court. Ultimately, Supreme Court paved out the way for the government in 2010. But because the company bill was already pending before the parliament, ultimately Companies Bill became a reality in 2013 and became Companies Act 2013. And Companies Act 2013 also provided for constitution of NCLT. Similar provisions as were there in 2002. They were introduced in Companies Act 2013. But again, the provisions were challenged before Supreme Court, and ultimately in May 2015, Supreme Court again upheld the constitutional validity of the provisions pertaining to NCLT constitution. Now, these provisions under Companies Act talk about constitution of NCLT for the purposes of NCLT, for the purpose of Companies Act only. It didn't envisage tomorrow this NCLT may become adjudicating authority under any other law. That was not envisaged at all. So when this legislation came in 2016, IBC wanted some adjudicating authority for corporate persons. So government को क्या लगा? Okay, we have one tribunal with us under Companies Act. Let's give this jurisdiction to them only. So NCLT was named as adjudicating authority, without thinking that speed is the hallmark of IBC. There are days of 7 days, 14 days, 21 days, 30 days, 90 days, 45 days, 180 days, 270 days. All these timelines are there. All these timelines cannot be operative, cannot be made effective unless we have a strong adjudicating system in place. But under Companies Act, NCLT was constituted with 63 members. This number was not changed. Number of benches was not changed. That was a major flaw. Okay, 2016 gone. 2017, government, particularly Ministry of Corporate Affairs through various ROCs, struck off more than 4 lakh companies, which we call shell companies. Now there is provision under Companies Act and Section 252, an appeal may be preferred against the striking of order. Thousands of appeals were preferred before same NCLT, which was already overburdened. So these appeals were preferred before NCLT. Now NCLT is busy in disposing of these appeals also. When this entire process was on, we had COVID. At least more than 2 years we had COVID. The speed again slowed down. So whatever the delay, okay, and that's not the end. Then came 58F explanation, real estate matters. All allottees are also financial creditors. Then came Pioneer Urban, that financial allottees have been financial creditors since inception of the code. Multiplicity of litigation. In one real estate matter, you will find 50, 60, 70, even more than 100 applications also. Unless these applications are adjudicated, resolution plan cannot be heard. So delays because of those reasons also. So after all this, certainly it has to take time. Recently, a number of times, me and my senior in the bar, Mr. Nagesh, we met NCLT president. I met NCLT president on behalf of PhD Chamber of Commerce also. There we discussed this issue. The president NCLT is of the view, and everybody is of the view, to be very frank, that the number of courts in a country should commensurate with the population, number of people in that country. Now, in same principle applies here also. If NCLT was constituted for the purpose of Companies Act, and in Companies Act, friends, today we have more than 14 lakh active companies. 14 lakh active companies, 16 benches, 63 maximum strength, out of which practically during COVID period we had only 32 members. Even as on date, we don't have full strength of 63. Recently, some members have retired and some have resigned, so effective strength around 52 as on date. Though the government has started interview process, but still the maximum strength cannot go beyond 63. So what the president also advised us, that if we can speak to the ministry, that the maximum, that we require a strength of 200 members in the country. I have given that representation through SOCHM as well as through PhD Chamber of Commerce and Industry to the government during last 2 months. Maybe that might have some impact, that Madam Nirmala Sitharaman has also spoken in the parliament during the budget session, during the budget day, as well as the day before, while responding to the query of Mr. Shashi Tharoor. She responded that we are going to have more number of NCLT benches, we are going to have more number of NCLT benches, we are going to have more number of NCLT members also. Even in yesterday's one of the newspaper has said that we are going to have 30 benches with 115 members in NCLT. I wish that becomes a reality very soon, and I'm pretty sure that may become reality within next 6 months, say by December and or so. If not in this budget session, maybe by this winter session. And if we have those number of benches and that much number of strength, I think whatever is prescribed in law, particularly in IBC, that is the speed, we will definitely see speed, and we will definitely be having resolution within the prescribed period of 270 days or 30 days. I'm very pretty hopeful of that. Thank you.
Thank you so much. Actually, you do hit the nail at the right point. And I think it is also important to have some capacity building for the adjudicating authorities as well. I think the IPs have the concept of having the continued legal education. I think there is no harm in also having that kind of a capacity building for the adjudicating authorities, because there is a lot of new things which are coming up. There are a lot of newer challenges which are coming up, and not every time the adjudicating authority is actually aware of a lot of those challenges, and therefore considerable time is actually spent in also making them aware with respect to those issues. So I think that is something that also needs a certain amount of focus. Now coming to you, Pooja, because this is something that I did touch upon in my opening remark as well, is with respect to the avoidance transactions. I gave the data and statistics to say that the avoidance transactions are facing a lot of challenges, and except if we take out the JP Infra, I think there are very few in terms of numbers and value that has seen success. So what do you see to be the real challenges, and what do you see also to be the proposed solution for those kind of challenges so far as avoidance applications and transactions are concerned?
Thank you, ma'am. See, avoidance is a subject which I have been speaking about since a very, very long time. luckily, a lot of landmark jurisprudence has been made in my matter, wherein the definition of the preferential transactions has been laid down by the Honorable NCLT and then the Honorable Supreme Court. And I think it's one of the few cases in the country where money has actually come back from an avoidance and been distributed among the secured financial creditors. But the journey has not been easy, because there had been a lot of conflicting judgments which had come. There was a Venus Recruiters judgment which had come that had been misused to a very large extent. To fight all that, it took me at least 3 to 4 years after the plan had actually been approved and implemented and handed over to a new resolution applicant. So the fact is that even today, even if, in my matter wherein the money has come in, but now I'm seeing new gray areas in the law, because in these 6 to 7 years, a lot of gray areas have arisen, and where we need to plug them are the decisions which need to be taken. Specifically, now the PG provisions have come in. So after, since last year, now even adjudicated avoidances are becoming a part of the repayment plan in a PG provision. So this is a new area. This is something wherein the judgments have to come in. So even if there is an avoidance as an RP, it is my duty under Section 25 to file an application for avoidance. Even if it is adjudicated, even after 4 years after adjudication, the personal guarantor himself would file an application, get the benefit of interim moratorium, say that I would give a repayment plan for an adjudicated avoidance, and also this is not a part of the excluded debt. Excluded debt is a debt which is, which has to be paid in a repayment plan. So they say, no, that is not adjudicated. If there is an avoidance which has gone up to the Supreme Court, so what I have made a lot of presentations, a lot of papers, also submitting to the NCLT, in cases where an application of avoidance has been adjudicated. Even in those cases, let's say there is 100 crore avoidance which is adjudicated, and the personal guarantor files himself an application of PG and says, I can only pay 10 rupees. So is that allowed? Isn't that a misuse of the provisions of the IBC? And more importantly, the time which is taken, because sometimes, a lot of times it is said that, the RP becomes, functious officials. He's no more an RP. So every time an application which is filed against me is erstwhile resolution professional, erstwhile monitoring professional, and I have no option but to fight it. Because otherwise that is, we need to make NACRR type of a specific, any avoidances, who can look after them, in the best capacity. So we need to, form an institution wherein any avoidances, as an RP, our work is for resolution. As a liquidator, it is for maximization of the value of the assets. Yes, we are fighting the avoidance because it is our duty, but the fact is we need, some specific professional institution who can actually take up the avoidances post-approval of a resolution plan or post-approval, of a liquidation. Yes, it is mentioned in the, a lot of amendments have come in the regulations which say that who is going to look after avoidances needs to be mentioned in the plan now, and also that you can actually, assign an avoidance, but then there is conflicting judgments. The problem is there are certain judgments which say that you cannot assign avoidance application in a NRRA, which is not readily realizable assets. An application then which does not get adjudicated, it takes years. So if you cannot, neither can you assign it, neither do you, and you're supposed to finish a liquidation maybe in a year, or, and there's a time-bound process. So where does the time go? I feel that it is very important that proper steps are taken so that the avoidances are properly pursued. The grey areas vis-a-vis the PGs, which are now arising, this is something new. These need to be plugged in right now. And most importantly, another thing which I've seen recently in the past, a year, now there's been so much time. So how to misuse the provisions of law has become there are certain promoters who are not even giving the information. And the non-cooperations, of course, go on for years. When they don't give information, they give you a 4-year back information. So any avoidance also which you file based on that, there is always a disclaimer. The auditor will give you a disclaimer. You will give a disclaimer in the application you file. And that grey area is being used to an extremely large extent. And nothing happens of the non-cooperations. So when you go to the court, I mean, I've actually had a bench member ask me, what can I do? I can ask you to, I can ask them to provide the data to you. I know they haven't provided 4 years data. I know they have sold assets worth hundreds of crores in this last 1 year, but they're not providing the data to you. I do not have the powers to actually do anything more than ask them to provide the data. So they're like, you go to the court, go to IBBI, go to the ministry, tell them to give us the, enable us that we can actually use, and if there is genuine non-cooperation, and which leads to avoidance. And why is there non-cooperation? That's what I'm trying to get at. Recent non-cooperation is because they do not want the RP to actually find out the avoidance. So these are some issues, and this is a topic I can talk about hours, so I think I'll stop now. Thank you.
No, thank you. And I think, this session is being recorded, and the whole idea was to ensure that whatever inputs we get, we are able to take it to the right authorities, and at some point we are also able to get ourselves heard in that sense. So thank you for sharing some of the inputs. Any of the other speakers, if you would want to jump in with respect to the issue of avoidance transactions, please feel free to put in your comments in that regard. Otherwise, I'll move on now to the group insolvency, and coming to you, Mukul, because I think this is something that I did touch upon in the initial comments also. But then group insolvency is something which has evolved at the time with respect to judgments, and I think Videocon judgment was the first one where we touched upon the issue and we realized the issue of group insolvency. Now, there are multiple kinds of challenges which arises when we talk about group insolvency, whether there will be only one IP, whether there will be multiple IPs, and if there are conflicts, how do you address those conflicts? So, I mean, what do you see to be the key challenges so far as the group insolvency is concerned? And then what are the kind of, legislative amendments which are required in terms of, legislative framework to address the challenges which are arising out of the group insolvency? And that is a question that I would want to also understand from Mr. Nagesh and from Mr. Risham Garg as well. Because this is something that we can actually, again, dedicate an entire session to talk about group insolvency. So I guess I will leave the floor.
Yeah, thanks, Shweta ma'am. First of all, thanks for having me here. Now, group insolvency is a big issue, especially for foreign funders. I come from Cube Highways. We are basically a private equity funder into India. So when you have foreign fund investment into India, all these things matter a lot. Now, why it is so? See, from a lender's perspective, whenever you're investing into a company, you invest not only in that entity, but looking at the pedigree of that entity, means what entity belongs to which group, what are the entities, and likewise. So you invest in there. Now, suppose if the person who has taken that money, he just through an RPT transaction siphon that money to some other entity, take a bet in some other entity. I have not given him the loan or the debt to bet on that risky investment. But this person goes and does a bet there, and the bet fails. Now, and because of that, this entity is not in a position to pay back the loan or pay back the money. I have the right against this entity to go and sue him under IBC or other ways. Now, the problem is, now this entity has already siphoned off that money there. Obviously, avoidance becomes one of the key parameters there. But then again, I suffer a lot, and now I cannot touch on other entity because they are two separate legal entities. So that is one thing whereby this group insolvency covers that phenomenon also. That yes, then I have a right to touch even other entities who have been benefited out of these transactions. So that is one which we should really think about how to incorporate. Interestingly, on group insolvency, there have been a lot of papers written by IBBI and by NCA. In 2021, this framework was there. But all these frameworks, they only talk about the procedural consolidation, as Shweta ma'am was discussing. There are two types of consolidation there, substantive consolidation and procedural consolidation. The difference is in substantive, this is what it is. If there's a common control, if there are common assets, common liabilities, then I can go and do an insolvency against the entire group or against all those entities which are benefited by the transaction. But procedural consolidation, which right now the paper talks about, and I guess which will become law in some time, is only if there are two different insolvencies of the same group, how to consolidate them, how to issue those procedural things. Obviously, that is important, but more importantly, from a lender's perspective, is the substantial consolidation. And Videocon judgment definitely touched upon that in that case, how to consolidate. Interesting, SBI was the lender, they are the main lender, and therefore in Videocon's judgment, they consolidated 13 out of 15 entities of Videocon based on various parameters, and they touched upon various US laws to do this consolidation. So that is where I feel the group insolvency is very important. But right now, the focus should be more on how to create the substantial consolidation. Interesting in the papers also, what they have said is that the jurisprudence will evolve through various judgments of AAs and Supreme Court, etc. in coming times. Then maybe we will be ready in coming times to devise a framework for this consolidation. So we have to wait for those judgments. But right now, at least some talk is going on there, which is a good thing. Hopefully, a good group insolvency framework in the country will really help bolster the insolvency scenario in the country and the confidence of investors to invest in the country. So there are my thoughts.
Please go.
Yeah. Thank you, Shweta ji. At the outset, I would like to congratulate Hammurabi and Solomon for this very timely and topical conference. It's just the budget has started and we're all awaiting, what amendments in the IBC are likely. And I'm sure this conference will throw up some ideas. And we surely look forward to some wonderful and interactive suggestions. Now, it's wonderful. Before starting my observations on group insolvency, I'd like to take a cue from Mr. Madaan. I'm also a student of law, and student means that we are always eager to learn and share our views. So, interestingly, going back again to 2002. So the decision was also taken because at that time there was SICA and BIFER. So decision was taken to abolish SICA and also to do away with the BIFER. And then, the CLB was operating simultaneously. So they were creating complications. And, the decision was taken to set up NCLT in 2002. And interestingly, the RBI had also come up with the first bankruptcy code in 2001. So if you see on the RBI website, there is a draft bankruptcy code of 2001, which was drafted by at that time Professor Anil Mitra. So it's another thing that NCLT could see the light of the day only in 2015, and Mr. Madaan has enumerated journey. But the interesting part is that it's not only the corporate issues for which NCLT was constituted, but it was also for resolving the corporate insolvencies, and we did not want to adopt that same DIP model, which was in SICA, and the experience of BIFER was not very comfortable. So learning from that, some cue was taken into the BLRC, when the BLRC was constituted and the draft IBC was released in 2015. Now why I'm saying this is that one very raw issue is that NCLT is not only for IBC. NCLT, as Mr. Madaan has rightly pointed, was created primarily for the corporate law issues, and all the lawyers, NCLT bar, they know how many percentage of corporate law matters are actually being adjudicated in NCLTs these days. So it's not NCLT, it's most cases an adjudicatory authority. So setting up new benches, okay. So last year I had written one research paper which was published in the Insolvency Law Review, published by the Insol International. So basically, my view is that, and lawyers also see the value of tribunals vis-a-vis the courts. Recently, we saw one honorable tribunal member pointing out that why high courts may consider tribunals as subservient to them, because the very reason why this Madras Bar Association judgment of 2015, which was authored by the Supreme Court, NCLT NCLAT will be at par with the High Court, and that is the reason why their appeals will not go to the High Court. So that is one reason. Maybe instead of having more benches of NCLT, we may think of specialist IBC benches or specialist IBC courses maybe in the future. So that is one thing I would like to point. Apart from that, the courts have inherent jurisdiction, the courts have jurisprudence, which may not automatically vest in the NCLT, which is maybe not tested, but I don't know, but it's certainly there. So the courts, high courts were established in 1860, and the subordinate courts jurisprudence, it stems from 1860. So we have a huge body of over 160 years of jurisprudence in the courts, that courts system. To what extent the tribunals can, exercise their jurisprudence and inherent powers, we still don't know. Because, a lot of these aspects, which group insolvency and especially cross-border insolvency, it depends upon this tremendous jurisprudence that we have in our court system. Now, as far as the issue of group insolvency is concerned, the CBIRC 2, which was the committee to frame the group insolvency draft law, which is the draft part ZA. So it is draft part ZA because it will be, if it is proposed to be inserted into the code, so it will be a part of the IBC, like the cross-border insolvency part Z, then part ZA. So this will be a part of the code amended into the code. So it defines the group as where two or more corporate debtors are interconnected by control and significant ownership. Now this is not defined as much, but we can understand that control means there must be some significant control regarding the management, and as far as the significant ownership is concerned, we can take cue from the Companies Act, because IBC in section 3 provides that the definitions in Companies Act can be adopted in the IBC as well. So the associate companies, the significant ownership where 20% or more, some limits are there, so they can also be adopted. And that is as far as what draft ZA tells about the group. Now, as far as the jurisprudence is concerned, a lot of water has flown down the bridge after the videocon. There has been several judgments, and in several cases, the NCLT and NCLAT, they have not, stuck to that the slightly, detailed set of parameters. 14 set of parameters were laid down by the NCLT Mumbai in that videocon judgment. So now, they just look into the control and the significant ownership when there are cross obligers, and there have been some cases also in real estate companies where the NCLTs have consolidated and the NCLAT have also consolidated the companies. And I believe the distinction between the procedural and substantive consolidation is to an extent obliterated, or it is not considered by the tribunals in ordering these, because the consolidation is being ordered not only for CIRP but also for liquidation. So the distinction between substantive and procedural is obliterated. It may not be there in the code, but the tribunals, whatever they see, they deem fit, they are ordering. So I believe that the liquidation has been ordered in few cases, and we is yet to see how it pans through. Thank you.
Good morning. See, the issue of group insolvency stems from the doctrine of necessity. This doctrine of necessity is something which the legal jurisprudence encourages, because many times we may not be achieving our goal by undertaking the exercise of insolvency for a particular company. We need the group also. Then the other doctrine which is important is lifting of the corporate veil. We have seen many cases where once you lift the corporate veil, we have seen the amount being diverted from one company to another company. So that is also important to see first before even looking at the issue of group insolvency. So keeping all these parameters in mind, I think the legislature should come up with, of course, a legislation. But in the meantime, we have several judicial pronouncements on this issue. And explaining the concept of doctrine of necessity, we have seen, for example, in real estate companies, we have practically, I have seen myself, lot of difficulties where the land is owned by A company, it is developed by B company, and ultimately sold by C company. So in all these three companies, and if one home buyer goes and says that, listen, this project was sold by C company, which doesn't own neither the land nor the project, then how does the insolvency materialize? So in this context, RARE also says that all three of them are promoters. So once all three of them are bracketed as promoters, in these cases, I think even if you go for an insolvency of one company, the other two companies should be automatically roped in, and then there should be a group insolvency of this kind. And that will help achieve the object. Otherwise, we are just going into a tunnel without any light. So my take on this group insolvency is it's a welcome change that should happen. And I think one more aspect. At the time of admission of a matter, I would encourage the adjudicating authority to immediately ask the RP or the IRP to go for a forensic audit straight away. The reason is, parallelly if that is going on, he would be able to communicate to the COC as well as to the adjudicating authority. This funds of this company have been diverted to another company. That company is flush with funds. This is also owned by an associate or a relative of the promoters. Therefore, that should also be brought within the ambit of the group insolvency. See, ultimately, what are we looking at? We are looking at the stakeholders' benefit. Financial creditors need to be given their money. Operational creditors need to be given their money. Employees need to be given their money. And that can happen only when there is money coming from various sources. So therefore, keeping this in my mind, I think group insolvency is a very welcome change that should happen in the near future.
Thank you. Dr. Risham raised the question of supremacy of NCLT versus High Court. I think that issue emerged on 24th of this month, 3 days before. But I think in my opinion, the lawyer was not carrying the High Court order, and what he narrated there in NCLT, that High Court has directed you to hear this application. And NCLT says, who is High Court to direct us? I don't think the word direction would have been there in the order, because on the same day, Honorable Justice Sanjeev Khanna passed an order in my case, Supreme Court, while saying that adjudicating authority is requested to dispose of the application expeditiously. So normally High Court and Supreme Court use the word expected or requested. I have never seen using the word directed, so I think that's a word mil gaya, or the media is highlighting that word. How can direction be there to NCLT from a High Court? Dr. Risham, you also said, touched upon this, NCLT is not there for IBC only, and you said rightly so. Nowadays what is happening, and my dear friend Mr. Nagesh is also witness to that all mergers have taken a back seat. Recently, I had to withdraw one merger petition. Second motion petition was filed in 2022 March. And now I have to withdraw it because now all these holding subsidiary companies, they say now this merger is no more feasible, viable for us. So we are withdrawing it. Though in the withdrawal application, we didn't mention the reason. We simply said not feasible, viable. We didn't mention the delay. Had we mentioned the delay, the court would not have allowed us. Coming to group insolvency, in the discussion paper, it has been said common COC or common RP. But recently, last week only, one of the benches in NCLT has said, observation only, where 16 cases have been transferred to one particular bench through an administrative order. And it is being stated that they might be interconnected entities. So what the court has suggested, there may not be common COC, there may not be common RP, but is there a possibility of having common resolution applicant? As you know, this is a new concept which has emerged, and maybe the government, while coming out with the final document on group insolvency, might have to consider this also. Thank you.
One aspect I would slightly differ from Mr. Madaan about pendency. I think it's no rocket science to ascertain a debt and default. And you may have 100 number of benches, but still, if the adjudicating authorities and the lawyers are trained to actually help the adjudicating authority to identify the debt and default, it's a matter of 1 hour case. And let me tell you, it's like as our chief guest today, there is an authority, independent authority to ascertain that there is a default. We have an NACL website to say that there's a default. Fine, it may not be the only evidence, but reading the evidence, balance sheet of the company is before you, so the limitation aspect can be really looked into to say that yes, the debt is within time. Then now you have to only ascertain whether it is above 1 crore, that is easy if the balance sheet will reveal. Then the only question that needs to be adjudicated is the default. And to adjudicate a default, you just have to see an agreement or something else to say, sir, this is the time we gave him to repay the payment. He has not done it. That's a default. So you don't require much time to ascertain the default. It's only because we lawyers have the tendency to drag the matter, ask for an adjournment or something, it takes time. Otherwise, let me tell you, you may be giving mergers, you may be giving company law, but the adjudicating authority, if they stick to this, therefore we are also saying the adjudicating authorities also need to be trained, and therefore this colloquium and all is happening usually. That apart, now coming to the other aspect, what we are talking in terms of the pendency, I think 330 days is fairly achievable if all the stakeholders in the process, they are sufficiently trained and if they cooperate with the adjudicating authority. Like for example, today the delay is happening more after admission, not prior to the admission. So we need to examine that aspect also.
But I fully agree with you. I endorse your views. And Shweta, you said in your inaugural address that regarding infrastructure, this issue was also raised in the parliament a couple of days before when Mr. Shashi Tharoor said that in NCLT Chennai there is only one stenographer. This is there in the parliament, This is being discussed there. And the government should know that before the matter comes to parliament, the infrastructure could have been there. एक जगह हम कहते हैं employment नहीं है, और दूसरी जगह कहते हैं हमारे पास लोग नहीं है.
No, the law is also, I'm told, they have not appointed people on regular basis. Most of them are on ad hoc. I think the finance ministry should have taken this first, saying that they should have come up with the recruitment rules, recruited people on permanent basis. Instead of doing that, you're keeping people on ad hoc basis. And how will the work improve?
Absolutely. Well, in NCLT, our members are also not permanent, they are also contractual.
Actually, that is one of the points which Shweta has raised, that all judges are also required to be trained on the law. The current situation where the judges or the members which are being appointed are retired judges or the bureaucrats who doesn't know ABC of IBC. How do they expect that there will be a flow of proper adjudication by them?
Absolutely. Now moving on, because we can go on talking about it. I mentioned that group insolvencies as a topic also is something that actually can go on for a whole day. Now coming back to the second issue that I wanted to touch upon, and that is about prepacks. So for prepacks, we have been saying that debtor in possession as a model is not successful in the past, and therefore we wanted to transgress from there. And therefore, when IBC came into being, we actually spoke about creditor in possession as a model. Now, and I'm going to start again from you, Madanji, because you have to talk about why do you think that there is a likelihood of success of prepacks for the larger companies when it has not really been able to do so well so far as the MSMEs is concerned? And then, Pooja, I think this question I'll also pose it to you for your thoughts on this.
Here, I would like to speak in one sentence only. We need amendments in law. Unless a law is amended, prepack is not going to be a reality. Since the day PPIRP has come, I have been saying it will be a non-starter. In 2022, Madam Nirmala Sitharaman, and also in IBBI's annual day program, she admitted that we brought PPIRP on the basis of the feedback received from the stakeholders. But even after we have implemented it, it has not been successful. What are the reasons for that? She invited the stakeholders to come forward, give their feedback, give their suggestions. I don't know whether MC or IBBI so far asked for those feedback or suggestions. Till that time, the suggestions are invited, the law is tweaked, the law is amended in favor of the resolution of MSME. Till that time, I don't know, it's not going to be practically possible.
And more so because if it has not worked for MSME, what actually gave this whole thought that it will work for the larger companies, I do not understand. Anything that you would have to contribute?
I think I'd just like to say one thing. Prepack and for MSMEs, why it did not work? I mean, someone was discussing with me. Was we already had a section 240A, which was with Redway 229A. So, anyways, MSMEs always had the option that their own promoters or their own directors could come in and give a resolution plan. And it is pretty much vast. If you actually read because I've had plans where of the same promoters being, approved and implemented and doing very well, because it was only because of 29A Redway 240A. So prepack, when you see the larger perspective, is not really needed because why was it there that it will also save time and it'll finish in 90 days, 120. That did not happen. So, even whatever applications were actually filed and approved, there were, I think, only 4 of them, if I'm not mistaken. And it took a longer time than a normal CIRP. So if you, anyways, in the CIRP, which is there, you have the option of giving a resolution plan if you are an MSME, and except if you are a willful defaulter, otherwise you can give a plan. And then another thing which happened was the definition of MSME increased to a very large extent. So about 2-3 years back, so a lot of companies which were not coming under the bracket of MSME did come under the bracket of MSME. And so anyways, when 240A read with 229A was the option available, and CIRP is something which was taking, I think, as much time or maybe lesser than a pre-pack. So that is the reason that's why I don't think a lot of people felt the need for it. And even today I feel, because that option is still there. Your definition of MSME is huge right now. The asset base and everything, your definition has increased. So I think any promoter who genuinely wants to revive back and get back his company, anyways can use 29A, and I think in a smaller period of time. And now the resolutions are happening much quickly. There was a point of time when the resolutions were taking time. There was a backlog. Not now. Not now. When you see, now everything is on priority. In the NCLTs, the approvals of the plans are actually taking a priority over everything else. And a lot of approvals are being done. So that's, I think, it wasn't serving any additional purpose. That's my one line on it.
Yeah. So just, taking the cue from the keynote speaker, the preventive restructuring is very interesting, and the RBI restructuring scheme could work good, before, so now we have 29A, and the pre-pack is contrary or like antithesis to 29A. So how, in a phased manner, in case of any, let's say, pre-default restructuring, which would be like a preventive restructuring, the RBI restructuring scheme could be resorted to, and as like the IBC and the NCLTs now are saddled with legacy cases. So let's have those legacy issues resolved through the RBI restructuring mechanism in a preventive restructuring manner before introducing or adopting pre-packs to the ordinary corporates as well.
Cross-border insolvency.
One line.
Yeah, please.
See, pre-package is something like an OTS being given before admission, similar to that. And this concept of OTS is there even in reverse insolvency. So what I'm trying to say is that, of course, as a trial basis, we should expand the scope of coming out of MSMEs also in pre-package, and seeing that in any case, if you see, the members of the COC are unrelated financial creditors. So we have no problem there. So the financial creditors should sit together and say that, listen, rather than wasting so many days in a typical regular insolvency, let's have a pre-package. It will benefit, because it should be confined, in my opinion, to companies where they're going, as a going concern, they're still continuing. Because the first 2 pre-package even I did was the company were in construction and the construction has stopped. So somebody came and gave this pre-package, and that got admitted, and now the base resolution plan has come, and then they admitted, and now the resolution plan has also been considered, and it is coming for final approval. So I think it's worth considering coming out of MSMEs. Yes, that's good.
I will just simply say one sentence, that I agree with Mr. Nagesh that PPIRP is nothing but extension of OTS. Had OTS been successful earlier, we would not have seen IBC. Because OTS was not successful, that's why IBC has been there. Now, in the same format, PPRP cannot survive. We have to change it, which has to be different than the OTS.
True, and probably removal of Section 29A is something that is worth considering now, because it has lived its life. At that point of time, it was necessary, and probably when we are talking about now PPIRP to be introduced for larger company, it is also time for us to consider that. Moving on to this now, and this is a question to you, Mukul, and this is that, under Section 323, there is this definition of persons which also includes, foreign creditors and persons resident outside India. And that was the judgment of, that Macquarie versus Shilpi Cables, where Supreme Court has probably, extended the definition already. Now, if you look at Section 235, it also enables the adjudicating authorities to be able to, reach out to their, counterparts to be able to ensure that the orders that are passed are also recognized in that sense. Now, in these kind of framework that is already, is already existing, do you think that there is a need for a legal framework for cross-border insolvency? That is question number one, but there are multiple questions out of that. Is it necessary to talk about cross-border insolvency at this stage? Because I think for the last 5 years we have been talking about it, but I don't know how many cross-border insolvencies are really likely to happen. There is also a counter view where people say that actually if you are having a proper regulatory framework around cross-border insolvencies, you will see there to be a surge of foreign players who are also interested in Indian companies to be able to come and invest into those companies, and probably we'll have more RAs who are foreign companies who probably will find a space here. So I think these are some of the thoughts. So there are contrary views as well, but I would want to understand from you, what is your view with respect to cross-border insolvency? What is the kind of framework that you are actually looking at? And is there a need? That is the first thing that probably needs to be responded to.
So I'll just take a cue from what Mr. Nagesh said, the doctor of necessity. So very rightly said, and I very rightly articulated for group insolvency, that yes, what is required. So cross-border insolvency, again, and as you rightly said, it can be a double-edged sword. One is it can really boost foreign investment into India, because if there's an Indian entity which has an entity abroad and that has gone to insolvency, and if they can also bid and thereby they can come to India somehow, it can bolster those things. Or like if a foreign creditor is there and the person is allowed to invest into India through this route, that is definitely there. But the biggest problem is, again, like Mr. Madaan said, for group insolvency, we're seeing a lot of procedural issues. Beside the substantive part, the procedural issues are so many. In cross-border, that will multiply it much, much more. First of all, we have to see what kind of agreements we have, like 235, 234 of IBC says. We have to have a treaty with that country. What kind of treaty we have? What kind of treaty that country has with some other country where also the assets are there? It's a very complex game. Right now, I do not think so that Indian insolvency regime is that well settled that can really withstand this kind of legal burden on it right now. Given that when group insolvency, domestic insolvency itself is a task to be achieved right now. So cross-border insolvency, I am very bullish. It is a very good idea, but maybe this idea can wait for some time now, instead of right now burdening it with the country. But then again, this is a talk going on, and you said it's already going on for the last few years. A lot of papers have been written. In fact, United Nations model law on enterprise group insolvency, MLEGI, is there, which has been the guiding force even for the Indian policymakers. So it is there. But I feel let's just hold our horses for some time. We have 234, 235, and certain other provisions. So let's just see how it goes. And maybe, but whenever we go with cross-border insolvency, we definitely need a much stronger framework. And obviously, this draft Z is coming up with this. But maybe, I guess they can draft it. They can just wait for some time before implementing it. Is what I think.
Dr. Garg, I think I would come back to you, because we did talk about draft Z and whether that draft part Z is sufficient, adequate, or you think there is something more which can be added in order to have a robust cross-border insolvency framework in India?
Yeah, thank you. It's a wonderful question and a topic. And first we need to understand why we need cross-border insolvency. So as the question also puts, let's say, the resolution plans. So we need to increase the value, and there can be foreign investors, and what they look, the ease of doing business, the business climate, and to supplement the business climate, the legal regime, the enabling legal regime. So if there is an enabling legal regime, they will be confident, they will feel incentivized to put in the money in India, and when things go wrong or they want to exit, they have liquidity crunch in their country, they can immediately withdraw their money and they can move out. But anyway, to supplement the ease of doing business, the legal regime is also required. That is one part. But the first thing is, what is the first challenge faced by the RP? Okay, RP, and then they go to the legal experts for the advice. I remember early on, Videocon and some other cases. So the first responsibility of RP is to take control of the assets, okay? And assets are lying in other countries. Now you have to take control of the assets. What will you do? You will take the order of NCLT. This is a moratorium, and I want to request the court of that particular country, let's say maybe any country, Uganda or UAE, that please recognize this moratorium, and these are the assets and these should be stayed. but the local creditors may want to sell them. So now, if there is no legal regime, it depends upon the principle of comity. So even though we do not have any cross-border insolvency regime or bilateral treaty with US or maybe UK, there are limited number of countries which are notified under Section 33 of CPC, the direct enforcement. But now UAE has also been added. So there are a lot of aspects why a legal regime is required. So some countries may recognize the foreign court order on the principle of comity, but several may refuse. They will say, well, we do not have any legal treaty. And even Section 234, 235 of the IBC have not been implemented. There is no treaty. So they are non-starter. That is, if there is no legal regime, then other methods like diplomatic and so on will be resorted to. What may be the dangers, what may be the considerations which are on the mind of the policymaker, they would know better, because the draft part Z was released in 2018. The detailed rules and regulations were also released in 2020. So it's 6 years and 4 years respectively since we have a draft law and awaiting implementation. Now, as far as the law is concerned, the draft law is concerned, I believe there is no such issue, because it is drafted on the model law, and the model law is a suggestion by the UNCITRAL or the UN body who frames these draft laws, so that the different countries may have a similar type of a law, and the other countries' investors, the business people, may feel confident that law is the same across the board, across the world, and any particular country is not tweaking it too much. But it's not a treaty, it's different, it's model law, and we have adopted the model law for international commercial arbitration in as much, as close as possible to the model law mandate. So model law is okay, but what we can do is how to adopt the or implement the model law in a phased manner. Maybe we can have a list of countries which we have, let's say, on a bilateral basis, or just maybe some criteria with which there are more transactions, there are let's say no tax havens, so we exclude those tax havens because we know that there will be shell companies, and the jurisdictions may not be well developed, may not be having those well developed legal regimes. So maybe for starters, maybe those 10, 12 countries may be looped in just like the CPC schedule. Yeah, thank you.
Yeah, actually this cross-border insolvency has creeped into personal insolvency cases also here in India. What has happened recently, in one of the cases, one of the foreign banks has given loan to a foreign entity incorporated outside India. Now one Indian has stood as personal guarantor there. Now this personal guarantor who is in India has given personal guarantees in India also. Now in India, the personal guarantee proceedings have started and application has been admitted. Now that foreign lender who has given loan to a foreign entity has filed a claim here. The guarantor says that this claim cannot be admitted because there is no bilateral treaty between the two countries. So therefore this claim cannot be admitted. Now Resolution Professional has kept this claim in abeyance for this reason. Now the foreign bank is in the process of filing an application before NCLT. Let's see what will transpire, because law is not clear on this.
No, that is true. In fact, we saw this also with arbitration because of the lack of bilateral treaties with different countries. To enforce the award also became a challenge. And then we had to initiate the entire proceedings afresh. You have to file a suit and then see the recognition of the foreign award. So I think that there are definitely a lot of challenges in that regard. But I have been told that there is only 5 minutes left, and it is very important to ensure that we stick to time. And therefore, I would want to now open the floor for questions if there is any, because we have a stellar panel, and I think any questions or any thoughts or any suggestions that you would want to give, please feel free to please share your comments on the topics that we have discussed.
Hello, respected Counsel, and I heard a lot about Nagesh sir also. So it's nice to be here with all this honorable panel. First of all, I have few suggestions. In fact, the timeline given in IBC for IPs, it's mandatory. But timeline given for AA, it's recommendatory. So this is, I think, first thing should be corrected, or some recommendations should be given to AA about the timeliness. And second thing is that, yeah, of course, more benches should be created, and some benches should be exclusively reserved for the IBC purpose, in my point of view. And third is the whatever did wrong, or what can you say about this, by AA, some relaxation to be provided to IP also for time limit, timelines. And ma'am already, I think Pooja ma'am already told me about the erstwhile IRP. It's a major thing, and it's a painful thing for erstwhile IRP. Here the IRP or RP removed by AA, whatever manner, either a COC or may. But cases continue till 5 years, 2 years, 3 years as erstwhile IRP. It's really painful for the erstwhile IRP. It's a burden for. So some relaxation should be provided. Either some legal help to be provided by either IBBI or somebody else to that erstwhile IRP, in my opinion. So I think that's it. Thank you.
First one, the timelines. See, adjudicatory process is not in a straitjacket. So you have to have that relaxation for the adjudicatory process. Therefore, it's said right from the Supreme Court, which had said that every process before the adjudicatory authority, including the rules, regulations, etc., they're all directory. So therefore, it takes some time. So therefore, even the 330 days, etc., it's all directory. No, but for IPs are concerned, when you're saying it's strict, see, we have this concept of force majeure everywhere. You can apply it, saying for whatever reason, sir, though it is strict, but then it is something you are tasked upon to complete it within a time frame, so that the adjudicatory process continues effortlessly. So that's the only thing that I think they put it as a mandatory to you, to the IPs. Otherwise, I think, in my opinion, a relaxation should be there. It's not mandatory that it should be within a timeline. That's one important thing. In fact, and that's what I'm saying. NCLT is an adjudicatory body. So adjudicatory body cannot be pinned down to a particular time frame. Though you have this 14 days time frame to admit a petition, but still Supreme Court has said that it is directory, not mandatory. But still, the effort is to complete it within a time-bound manner. Everybody is doing that. It involves several stakeholders. Therefore, everybody should be bound by their timelines. That's what I'm only on the timelines issue.
Out of hearings in a year, in any particular case, hardly the matter comes up only 3 times in a year.
So what?
Hearings.
But Ranjit ji, otherwise also timelines for IPs is also directory in nature. You know, CIRP extension milti hai aapko, liquidation process extension aapko milti hai. Form G you can come out with number of times. Where is the restriction? The courts are very liberal in that. You know, you get all that's a separate issue, but you get all the extensions from the courts.
No, but as I said, that out of the 12 hearings, in any case, hardly about 3 times the matter comes up. Rest of the time, the matter is adjourned due to paucity of time.
No, that is because of the infrastructure. I'm not on the infrastructure.
I think it is not only because of the infrastructure, but there is a tendency on the part of the judiciary also to look into it in a very positive manner.
Pooja, you wanted to say something?
Yeah, just 2 minutes before we finish. We are talking basically about the amendments, which the IBC is now going to be making. But what is most important is we need to, the judicial intent of the code needs to be corrected, because somewhere along the line, the preamble where the IBC was actually formed, the rationale about deprioritization of the government dues, and there have been so many conflicting judgments that now is the right time to actually give the right jurisprudence. Maybe there are a lot of issues with reference to Section 53, first charge, second charge, whether who is, there are genuine issues which are concerning, that is the reason the resolution plans are not getting approved. It's taking a long period of time. So I think this is the right time to properly clarify the waterfall mechanism, to properly clarify the jurisprudence with reference to government dues, whether, of course, everyone knows about the 2 or 3 judgments which have come in, wherein there has been, that is one reason for delay where we've actually been talking about. So this is the time that there has been so much jurisprudence formed. I think now the clarity needs to come in the law itself, and especially with reference to, there are issues with reference to EPF, gratuity, funds not being there, the funds are not created, but then they have a priority. Nobody's talking about it. Nobody's talking about the fact that so many companies are being pushed into liquidation because of excessive claims. Sometimes it's been formed, given by EPF department. Gratuity is payable, but you don't have the funds. So they say, in a liquidation estate, it is not a part of a liquidation estate. But the Section 53 is different. But somewhere in the judgments, the Section 53 and the liquidation estate are being intermingled. And that is why a lot of confusions have arisen. So now is the right time to clarify those, when we're talking about amendments, this is what we need to do. That the intent somewhere about deprioritization of the government dues, which was one of the main rationales, has gone with a lot of jurisprudence. I'm not saying it is right or wrong, but it needs to be, settled in the law itself now. So, so that there is no unnecessary and frivolous litigation also further on. So that's
this
my
idea, Pooja.
Yes.
What has happened in the UK year before last is that all the avoidance transactions and claims are now transferred to the public prosecutor. So, which means the government is entitled to recoveries out of these avoidance applications and fraudulent transactions. So, if government or HMRC is suffering a liability or a recovery which is not due or which is not received, they are recovering the monies on account of these transactions. But nevertheless, a new amendment came in last year which made the directors personally liable for taxes, for social security contributions from the time the company has started to suffer insolvency or wrongful trading has begun. And in fact, the HMRC in the UK and the social security organizations would call the directors of the company for a personal one-to-one meeting, and they would take security from them for continuing to run the business on the assurance that these dues will not remain unpaid. So the world has progressed, but that law came in 1986. But just last remark, I came in a little late. I heard Dr. Garg saying that these tax-free jurisdictions are not that organized. I have a different view. Just see what BVI, Cayman, how advanced are they in their proceedings? And today the Hong Kong market lives on these tax-free jurisdictions in terms of insolvency proceedings, because every company is incorporated as a headquarter company in those jurisdictions, and their laws on insolvency are much ahead, sir.
No, thank you. Thank you so much for your contribution. I think it definitely, added value to the discussion that we were having. And I would now want to thank the panelists for such an enlightening discussion. I really, gained a lot of insights into a lot of issues. And I'm sure when we, come out of the room, we will be better aware and better knowledgeable persons so far as some of the amendments that we discussed. And thank you, Pooja, for adding on those last bits, because they were a part of the question, but we were running short of time and therefore we're not able to deliberate on it so much in detail. But thank you for adding on to that. And thank you, everybody, for listening to it so patiently. A big round of applause definitely is merited for the discussion.
Thank